I'm back. I'm back. I'm back. Hey, tea sippers. I am back. What it do? What it do? So do I start? Let's start with Cardi B before I go off into the other. And hitting the like button. Please come in hitting the like button. Cardi B arrived in court giving people the finger, the middle finger. Cardi B. Cardi B. Hey. She gave somebody the finger earlier today. Cardi B crazy. She crazy. Oh my God. She gave somebody the finger arriving. Arriving at court today. Cardi, why you giving folk the middle finger? Cardi B, what's wrong with you, girl? Cardi gave him the finger. I don't know what they asked her, but they asked her something, baby. And when I say she gave them the middle finger. Oops, I'm sorry. Let me fix that. That just fell all the way over. Y'all please come in hitting the like button. She look pretty. She just mean as hell, but she dang sure look pretty. Shout out to Cardi. Y'all come on in so I can get started.
Cardi, You ready to put all this behind you guys today? Hey, any thoughts on her character at this point? Now that you had some time to
Cardi, para el gordo y la flaca,
really
¿cómo
look at
estás?
it?
Cardi, ¿qué esperas hoy? ¿Qué esperas hoy, Cardi? Cardi, mira, le puedes firmar acá al chico.
Oh, that's what they asked her. Was she pregnant?
You can't ask a woman.
They asked her, was she pregnant? Is she having twins? And Cardi gave them the middle. Cardi B is funny. Where's she at? Oh, she gave him the middle finger. That clown don't ask me nothing stupid like that. Cardi gave the middle finger when he asked her was she. Oh, she had already walked on. Let's slow it down. Cardi said, "Don't play with me. Don't play with me. Play with y'all."
You can't ask a woman that, right? Hey, any thoughts on her character at this point? Now that you had some time to
Cardi, para el gordo y la flaca,
really
¿cómo
look at
estás?
it?
Cardi, ¿qué esperas hoy? ¿Qué esperas hoy, Cardi? Cardi, mira, le puedes firmar acá al chico.
You can't ask a woman that, right, Cardi?
All right, guys, I know it's a lot of sad stuff going on in the world, but this is not a funeral. This is a graduation.
Okay, so let's go to court.
Cardi.
I don't know what that is, but let's get to court.
9 to 3.
Oh, that was Tyree. Where was that? There's a lot going on. That's Don Lemon. He was at the Capitol today.
Voters should pick their politicians. Politicians shouldn't pick their voters. And I think
it's a lot going on. Stop. I'm trying to get out of this.
States that have independent redistricting committees, though, are Democratic states.
Why will stop?
California do, or try to do.
And we got something going on with Diddy. He in trouble, y'all.
We have to say, we hate that we have to do this. Yeah. We have to say...
Diddy's ass is in trouble. So let's get to court so that we can get to Diddy. With Trump's appointee, Coleman, I think is his name, who is not a Diddy fan and want him to get it. Hey, Willie Spencer wants him to get it. Oh, what is this, Lord?
Cardi's original bag is back now with even more full-size sandwiches to choose from. The new spicy chicken sandwich, hot ham and...
Oh, no, that's not it. I can't stand when stuff disappears. Oh, here it goes. Closing arguments today. Then we're going to talk about the trouble Diddy is facing. He ain't going nowhere. He ain't going nowhere, Auntie. He ain't going nowhere. Let's go. Can you hear?
That wasn't the original package. It was modified only because now that the damages are more limited than what Mr. Roosevelt was proposing earlier, we've just changed the last sentence.
Oh, okay. And I did not reach that on Wednesday. Is that correct?
I don't believe it.
Sure. Okay, so I'll give 3934.
Thank you.
Special instruction number 8.
And if y'all see the hype button, please hype me up. Hype me up. And hit the like button. Thank you, Crystal.
Is that punitive damages cannot be awarded if there was accidental harm. The second is to include the next. That's paragraph 3. Paragraph 4 is to include provocation.
Let me pause right quick. So it's telling me. Oh, I hope y'all can see this. Can y'all see? Shout out to let me let y'all see this. TZF baby. It's saying I hyped him up. And this is how it looks. So there's a hype button that looks like this. And I hyped him up. And it's saying I made a difference in hyping him up. So when y'all see this button, make sure y'all hype AunTeaFee up. Thank you in advance. There's something new they got coming out. Let's go.
As part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Whitkin states that it's proper to instruct the jury on provocation when they're considering punitive damages.
My understanding was the trial would be bifurcated and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the cases that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor, I don't really see a need for this one because there is a specific case on punitive damages that can be read.
I understand that. He is suggesting that it would be appropriate to amend the case to add accidental harm and heat of passion.
Accidental and the heat of passion. Oh, y'all, she finna have to pay.
This is an example of one that's really so far off and completely different than what the case states.
All right, submitted. All right, I think special instruction number 8 is appropriate, so I'll do that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
No, there's one more I need to add. 3932, life expectancy.
Life expectancy.
And it's the math, right?
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So, what evidence do you have that she will continue to have a future? I could testify that she is still bothering her.
Yes.
Any objection to 3932?
Yes, Your Honor. I'm not sure that she testified that it's so bothersome, but in any event, first of all, this was never shown to me. We're not sure that the math is correct, and this is just not an appropriate. This is not an appropriate instruction in a case like this, where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by the
Go ahead.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Violence Statistics Report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
Where's that chart?
Can y'all hear this? Cause they talking like.
That appears to be correct. This is 50.3. They've got 50. All right, I'll give 3932 over plaintiff or defendant's objection.
Okay.
All right. Plaintiff proposed 3901. I think I already gave 3901. That's not correct. No, I guess 3900. I just, oh. You're all right. Yeah. So 3901 is only if liability has been established, not contested.
I apologize, that's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
That's correct, Your Honor.
And it's the defense version was straight from the case.
Yes.
Now,
It's in the binder.
the one that I did, Your Honor, is from the case, which seems to have a lot more words than theirs.
Yeah, I already did give 3903.
We're gonna go with their version now?
It's straight from the case. 3905, I think I already did it. You ready to walk away? Go ahead.
So the one that I submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read.
I just looked, I did not give 3905 on Wednesday. And plaintiff is straight from the case. And defendant had a different one.
I think there's 3905A, so maybe that's why. I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define.
doesn't cover it.
Yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s. I made the mistake.
Your Honor, it was the 1602 instruction, which was the special instruction before we discussed it.
I did give 1600 already.
I withdraw the objection past the 1600s.
Okay. did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that, okay, so I'll give the modified version.
Hey, Mrs. Tom.
Thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so that.
I know I'm not supposed to use my mouth open. I don't care. One of the most popular products that Rebel Cheese has is tomato from.
I believe was given.
Was already given. All right, tell me we have an agreed upon verdict form.
Yeah, let me move past this part.
And what are the differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language.
Never decided evidence. She plaintiff didn't testify. She said she understood he died sometime.
She'll take it on the same day.
Doesn't even break down the 14 and argue how this form should be filled out. And as confusing it is to me, I'll have to just live with it. To take away, we can do it again for All-Star game was on February 18th of 2018, so it's just
Please hit the like button coming in, even if you're in the bushes.
when the game is.
Question, is this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say like,
More slowly, please.
sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks, is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24th, 2018. She doesn't reference the date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised, everybody was advised, that it was on February 24th of 2018. He later said she testified that she got the picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
And one other thing, Your Honor,
Go ahead.
my understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I can refer to.
I'm not necessarily worried about that. I'm just worried about whether, I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material. Go ahead.
The purpose of this is really not to make anybody right or wrong. The purpose of judicial notice is just to clarify the All-Star game took place. And the second half of it is when the photograph was taken. There's overwhelming evidence attached from different news outlets. There's
Again, is it material, the date? She said she had those nails for the entire week.
it's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, the exact same day. She had those nails. You have on the same date of the All-Star game and the same date of the incident. What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm going to deny her the judicial notice. All right. Are we otherwise ready?
I do give it to the court. It would say plaintiff testified that she treated with John Scher MD in relation to this case in 2018. It is undisputed that Dr. Scher died on March 5th, 2020.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court can instruct the jury that it is undisputed that Dr. Scher died, period. This March 5th, 2021 date, understood he died sometime in 2021. She also testified, and we lodged the transcripts, I can cite to where the transcript she says it, page 148, lines 12 through 149, line 15, she says that she went to see a Dr. Scher, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Scher is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Scher died, period.
Okay, you heard. So, this is what I would propose reading. Plaintiff testified that she treated with John Scher and he did not dispute that Dr. Scher has passed away.
Your Honor, she did not testify she treated with Dr. Scher. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Scher? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So, that goes on page 149.
So I will read plaintiff sought treatment with John Scher and does not dispute that he's passed away.
Well, plaintiff testified. Plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Scher MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Oh, now we're ready?
Well, there's a couple things. In my closing argument, I need the verdict form, so I can't start without
We're working on that.
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in the closing.
That's not evidence. I think what you said was they didn't provide the date. Then you're fine. You can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing.
You could argue it. You could argue that they didn't establish what the date was.
And also that the All-Star game was on February 18, 2018, the week before. But a week before the incident, I don't see the harm in that. They can object to that. They can say their version. But that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It's never produced.
Okay. Go ahead.
Just briefly, a couple of questions. First, if you remember, counsel violated a motion in limiting order. And now he's talking about arguing things that are not evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue things that aren't in evidence. He can't violate the motions in limiting.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If he wants to present that, you want to object, and that's how we'll proceed.
Thank you, Your Honor. And
He's saying,
two procedural questions. Does the second monitor work in entity facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition, and I don't know.
Okay. And
You can see it's not.
Your Honor's preference, we have demonstratives, we have things we're going to show or intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right, anything else, plaintiff's counsel?
Yes, Your Honor. I
Oh.
feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the video.
Correct. Your position on Wednesday was that they didn't establish the right date. Can you make that argument?
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right, are we ready to move to the jury?
I must have the verdict form before I start.
All right.
I'm waiting for you right now.
Okay. All right.
Oh, Lord. It got petty, didn't it?
Order of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent, and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress in suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under Factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar...
Cereal tastes better with a blue spoon. Now you can enjoy creamy, fresh frozen custard mixed with Lucky Charms, Cocoa Puffs, or Cinnamon Toast Crunch. Stay young at heart with the new cereal concrete mixers at Culver's.
Sorry.
Is expected to live another person is likely to live, but is not conclusive, probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive. In the damages from Ms. Almanzar under more than one legal theory, however, each item of damage asks to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Imani Ellis. Physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence of common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional stress, Imani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, actually, I think, okay, no, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Imani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar, if you define the defendant accidentally harmed, are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether the defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with the intent to cause injury, whether the defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction. And we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, Your Honor. I just ask for a quick sidebar for a moment, please.
conversation at sidebar. And now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words,
she cussed people out in court.
It's a disrespect to the judge. It's disrespect to this courthouse.
Did we miss the cussing out?
And say these kind of words. It's just disrespectful. And just because just because Miss also known as Cardi B is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people.
Hold up, maybe I missed it. Hold on. Maybe I missed it. Maybe I hopped too quick. Cardi, you... Girl, did you cuss some people out? Where you at, Cardi B? What have you done? Now you over here looking crazy. What have you done, Cardi? I told you the other day you was entitled. Cardi B, who did you cuss out? And why are you sitting here looking like you pissed off because he calling you out? Girl, you gonna lose this case. What did I miss? Let's see if I can find it.
And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar, or the cut, came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulligan, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails. And that there were 3 different scrapes, 3 different scratches. And that the middle one was the deepest one. And that's really the one that he worked on. Now, the issue in this case, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Ellis, just because Miss, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay? If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's degree. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are, Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes,
After I had my kids, I hit a wall I'd never encountered before. I was doing...
There has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you know, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person, and she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old, and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is,
Oh Lord, these state attorneys, they are
it
getting.
would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is, recording video is not available while on the call. So it couldn't be, the two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words.
That's an absolute no.
Word, to disrespect her, calling her the B word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher, a sentence that basically that there's this undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses, Miss Malcolm, which is the secretary of the doctor, and Dr. David Finke, were so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis,
Cardi,
calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening? Being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry, she was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that.
and they have assumed that it's her fault, maybe, or that she did something wrong. But again, those two witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she
Definitely is a risk.
got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified.
Is she falling asleep?
She did not know who scratched her face. She has no idea. What does that mean? Could be from either one. Could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really
Cardi
happened.
B is falling
Unfortunately,
asleep in court. Oh
there
my
was
God.
no other witnesses.
She
that
is falling
actually
asleep.
saw it. So you really
She
comes down to one thing. Do you believe Miss Ellis?
She falling asleep in court,
Why
y'all.
not? You should. She's a hard-working security guard. She was doing her job with no prior anything.
Oh. Is she going to sleep with her eyes open?
At some point during the trial, the defendant showed you Exhibit 232. Do y'all remember this photograph? Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to. We don't know when it was taken. There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Baby.
That was her testimony.
Oh, she done fell asleep. Or got,
Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken.
I'm gonna start snoring with her in a minute.
NBA All-Star game. There's no proof of that anywhere.
There, she out.
That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on
As she trying to sit up.
because there's no date on this photograph.
Oh my goodness. She can't help herself. Should have the upper, not the back. Keep your hands to yourself, girl.
Next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow
Hold on, y'all.
company policy.
She followed the company policy. Hold on.
Did what they asked her to do. She called her supervisor, made an incident report.
Look at her. She can barely keep her eyes open, y'all. This is funny to me.
Different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, downstairs at the building, she had a security guard with her, Mr. Newton.
Yeah, that's an issue for me.
That's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that
Oh, she got
when
them
she
short
saw
nails. I ain't even
this
paying no
security
attention.
guard downstairs in the lobby, she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified.
Well, child, ain't nothing we can do about it now.
He didn't. And there is a jury
Yeah, of course she
instruction,
does.
KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So, where's Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
Oh, he was on the witness list? But she had all them other paid witnesses who didn't see nothing.
Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will
Is he the judge or is this his closing argument?
what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make...
Yeah, I know. It's just like he making statements like he the
because there
judge.
were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness...
I mean, because he's repeating the judge's instructions. So I'm like...
Just because one side may have more witnesses...
Connected.
That's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw the Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. Medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lien basis. Dr. Mulliken testified that he would agree to that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Ms. Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Ms. Ellis to have plastic surgery and have this done in a surgery center. 2 different
she does not care about nothing.
Over a period of 3 to 4 months, so that Ms. Ellis could...
and she gave the reporter the middle finger coming in.
A little bit bit of hypersensitivity, and also, as a woman, she doesn't want to have a scar to her face, and all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind.
She got a Cardi B autograph on her face every day.
Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulligan says with a lot of importance.
Entitled brat. Yep.
There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulligan's work is no good.
Entitled aggressive brat.
We don't have that here.
She's very aggressive.
One doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA, and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves.
Oh.
Now, when you go back into the
now I ain't gonna lie, he is very boring.
See Dr. Mulligan's records and bills.
I lost 110 pounds. You couldn't tell it all because of my excess skin. So no better.
Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulligan in other cases. He's been an expert in other cases, working alongside.
Boring is one thing, disrespectful is you right.
This is a very
they don't even compare.
Doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding. They were raised. When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen, and that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony.
Cardi.
When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors.
Yeah.
Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained a scar to her left cheek as a result of this incident. Objection. Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. Yes, we've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries.
And then the doctor tells you to lose weight. Oh Lord, I missed that. Did he tell her that?
I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before.
Right.
It's like a car accident. There's two cars that
That's true. She wasn't.
The third car comes down the road a minute later and hits them. It's completely different.
You being snarty.
So that
Snarky.
was inserted into this case in a sense to muddy the waters, to kind of cloud what really happened. What really happened here in this case,
I was saying
Miss
that's
Ellis
true
was
that the
working as a
witness
security guard. She had to be there. She was
wasn't
working
a
as a security
witness
guard.
of the
And
incident.
Cardi B
She
came
was just
along
a witness
and saw
after
she's above the law. She
the
can do
situation.
and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you gotta be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to
Maybelline,
follow
where?
what they say.
You missed the live earlier.
Next, we heard from
I
Dr.
talked about
Finley.
Maybelline.
Want to talk about inconsistencies? There was an inconsistency.
What you mean
between
he's
Malcolm
here?
and Finky. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finky
Miss
comes
Tom,
out
what you mean
and
Maybelline is here?
that Malcolm told him that Ellis had scratched her face. That's not true. That was never said.
Oh yeah.
So
Yeah.
this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finky could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really this comes down to believing Miss Ellis. She gave you no reason
She's
not
my
to.
altar.
She's been truthful through me and through herself
The
and
main
through
one.
witnesses to give you whatever is there.
Who is your altar,
to
Mrs.
provide
Mrs.
for
Tom?
you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B. And Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her
She
walk
is
away
an
and say
entitled
everything
young
you did was
lady.
okay, and yeah, do it again.
What mean when Miss Tom? What you talking about?
Seeing the two plastic surgeons and Dr. McKenzie, Miss Ellis also received another 12 visits. She testified that she saw the psychologist, Dr. Avila, and other people in his office.
Violation of the court's order.
Move on. The other thing that Cardi B failed to do, or could have done, is she could have filed a cross complaint.
Objection, Your Honor.
Maybelline is my name from my knee. Oh, hilarious. Oh, okay.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure. another one to make it better. The cost of that was $15,000.
Objection here.
Oh. The $15,000 that would be paid for that would, in Dr. Mulligan's expert opinion, it would make the scar better, meaning it would...
Can y'all please hit the like button?
It would... Basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around, you can look at it for yourself.
Disrespecting title things.
There is still some scar on her face.
Falling asleep, yeah.
It's still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now, for today's purposes, is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering.
Cardi B
You are allowed to do that. It is a number that you can come up with. During the 7.5 years
and because she lied, she said that there was nothing physical happened. The girl didn't touch her. So if she didn't touch you, why did you touch her?
And for 7 years, that comes up to $270,000.
So she
We're
lied.
not looking for millions of dollars, like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do.
She's a pretty girl. She just got a bad attitude. And she feels entitled.
When you go into the jury room, you'll be given
She don't want what comes along with being a celebrity.
and the verdict form
Hey, Purple Flower.
will basically state it covers all of the different areas of this case. First, section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch or the cut to her face. However, it's very clear. Did Plaintiff Imani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question.
Bored.
Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2. Both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody, and nobody touched me.
Facts.
So self-defense
is out. I agree right there.
Then you can go. Then question number 4 speaks about the damages that she suffered. Past medical.
She dang sure said there was no contact.
Put in an amount of money through the testimony that
She do need to sit still.
all the exhibits. You would put an
but
amount
you know
of money
she's sleepy.
You believe Miss Ellis incurred in this incident. So you will have.
Yeah, that right there is enough for me. When she said it didn't get physical, the girl didn't touch me, and I didn't touch her. Well, she lied because the girl had a scar, but you admitted that she never touched you. Yeah, come on now. How'd she get a scar? Whether it was a scratch, whether it was you digging your nails, or your rhinestones hitting her. I don't know. But you said it didn't get physical, and it did. So you lied.
All of these bills, you will get 16.
Now I don't know if it's. I don't know.
Medical expenses.
Wasn't my face, so.
$16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulligan stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000.
Oh yeah, they could do some damage. I don't care how high or how low they are.
There's past pain and suffering and future pain and suffering.
And them long fingernails can cause, if somebody's swinging or even trying to, put their hand in somebody's face and somebody try to knock it out. I mean, it's just a countless of things that could have happened.
Basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have.
She does have a short fuse.
On all kind of statistics.
And she said, popping off. Oh, no, she didn't touch me.
If you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important.
Yes, they can. Them corners can, baby.
Because it covers all of the different things. Embarrassment.
I've accidentally scratched myself.
Disfigurement. All of those. So if you look at 3905, It talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that. So for past non-economic loss, you should put a number there. Because if you don't, the award will be thrown out. You gotta have at least $1 there. You gotta award some kind of pain and suffering. It's required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury.
This is Pod 5, the first fully immersive sleep system. Intelligent, adaptive.
Weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack.
I don't think it was violent.
She has a scar to her face now.
She may have a scar, but I don't think it was violent.
That she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almanzar engaged in extreme and outrageous
This taco, I want some lobster tacos.
Assaults, threats, indignities, annoyances, hurt
Taco
feelings, and other
Tuesday.
trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis
A
emotional
little
distress.
hissy and
Miss
clawing.
Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages, aside from the assault and battery, for the emotional distress, then this is where you can give that amount of money. It is separate and apart damage area for you to award more damages. Same breakdown. You can give past medical expenses, obviously past and future medical expenses. In this, if you awarded in the first box, then you would say, 0 and 0, because we're not asked double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give 50,000 additional for the past, 50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then, again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this.
Yeah, they stopped showing her falling asleep.
So anywhere on the form, we'd like
so I can show y'all here, because I was sick of her.
award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through. The assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%, and Miss Ellis, 0. And the final page deals with punitive damages. Did you answer question 4 or 7?
I can't believe he's a state attorney.
Back and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say, I've told you, and then I will have a chance to come back and rebuttal and just clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and work with her as best I could to convey all of the things that she wants you to know I worked with her personally to tell you all what she went through. And I did the best that I could with what I had. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each
he
individually
making
for
me
being
tired.
here. Each of you as individual judges, we're thanking you.
You're welcome.
Very
Goodbye.
much. Thank you so
Next.
much for hearing the story.
You're welcome.
As to what Miss Imani Ellis went through, and I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
You're welcome.
All right, thank you, counsel. Are you okay? You want to take a break? You okay? Okay, all right. Hands ready to proceed?
We are, but I would think a break would be appropriate.
Does anyone want a break? We got started late. Okay, why don't we take a short break? Why don't we resume back at 11:25? In the meantime, discuss the case with anyone, including other jurors, or form any opinions, or do any research. We'll see you at 10:25.
It started very late.
All right, welcome back, everyone. We're back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections to the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial. Please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial, okay? All right, with that, defense, can you give their closing?
Thank you. Good morning, everyone.
Please go faster.
Start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statements, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as
That's what he
promises
said.
that we're going to show. And then I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in. The witnesses have testified. The exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true, And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge.
And everybody
if the
pause.
fails to prove that her version of what happened.
Can I get everybody to hit the double tap your screen if you're on your phone, please? And if not, and you're on a computer, hit the thumbs up or the 3 dots at the top right corner so that it will take you to the thumbs up. I would greatly appreciate it.
Is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated on this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50% or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation, who caused the incident. And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence.
Listen, somebody had to get in between these two ladies.
The cause.
There was a confrontation.
The way I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart.
Hi, welcome in. I make guests smile every day. Oh yeah.
Oh, Lord. I'm sorry. Y'all missed all that good stuff I was saying.
Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt our criminal plan for you, but there's a logical place to stop.
I can stop there if y'all feel like.
Yeah, stop.
We're going to resume back at 1:30 the new time.
Cause he was beginning to lie too much for me. Was Cardi pregnant or was she not pregnant? Did she know she was pregnant or did she not know she was pregnant? I mean, being pregnant or thinking you pregnant does not give you the right to get up in somebody's face.
For the NBA All-Stars Weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star Week. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the incident, on February 24th. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernail.
No. But did she, I thought she said she wasn't feeling good and she was going to be tested. Did she know or did she not? So don't act like she knew she was. I just... And if she was pregnant, she shouldn't have popped up in that girl's face.
That was a new one on me. Apparently, coffin square means shape and square, and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy, and they had no sharp edges. Apparently, you can get rhinestones either with little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finky, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finky, well, excuse me, she testified that they were flat. Dr. Finky, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have two witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there. That it's my witness. Well, there's a couple of problems with that. Just touching chests like that is not an assault. And if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all of both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. We've heard the evidence. We think it's overwhelming that Cardi did not touch plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is assault by Cardi, which we dispute strongly, there is an instruction that the injunction is giving you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tierra's testimony, Tierra Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tierra Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who were in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of Plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. A defense counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door and immediately ran out when she heard yelling. Now we have a visual rendering based on Plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that Plaintiff showed you, defense counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far Plaintiff forced Cardi B backwards and into the corner that Tierra Malcolm saw her when Tierra opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that Plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the Plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing Plaintiff. The evidence is that at that point, Ms. Malcolm testified that Plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. After Dr. Finke came out and tried to deal with Plaintiff, Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified to, Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize, with Cardi behind her and Plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued that... I would object to him referring to counsel. Plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay? And he dwelled on that a lot in his cross-examination of Ms. Malcolm. And with all
that is what she said. She just assumed.
Plaintiff's hands flying in the air. What Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head.
She didn't.
But she did see Plaintiff flailing away trying to get to Cardi. That's why she concludes.
No, she said she was in front of her. She could see her, but she did not see her hit her. Oh.
Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi. Quote, I will F your shit up. That's what Tierra Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that. So she testified here that she was using earphones. She actually, we've got another witness who said the plaintiff was sitting there, standing there, flailing away with her hand, with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliver it. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked what about chest to chest, and Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Tierra Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. This plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt that plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He too was there the day of the incident, and he too has no axe to grind. He is not a regular doctor and never has been. He saw her at one occasion on February 24, 2018, when Cardi was here for work for the NDA All-Starter Bootcamp, and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tierra Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little more distance to cover. And he testified.
Okay, y'all, I gotta go. I gotta go. I'll be back later to talk about Diddy. This, I work,
trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. Gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway. And that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out. And also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood in her face from a scratch that is supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe that evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, the nose is not a cheek. They're different. This raises 2 points, really. plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Ally and the building owner, quote, for behaving the way I did. In fact, why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam. Can I have a little bit of extra time since Council got extra time?
I don't know if you did, but you turned around.
Okay. I'm going to do this a little bit faster and I apologize.
He told him to hurry up. Then he gonna say the council got extra time. Oh.
Because she's a psychologist, a workers' comp psychologist. But, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKinnon testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when she went with Dr. McKenzie, did the evaluation, plaintiff made no mention of being scratched, cut or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching.
You want extra? Eat the same stuff. Okay, I'll be back later.